I'm going to talk about aggravated vehicle taking. The law on aggravated vehicle taking is contained at Section 12A of the Theft Act 1968, and it was amended under Section 2 of the Aggravated Vehicle Taking Act 1992. So, the offence of aggravated vehicle taking is where an individual has unlawfully taken a vehicle without the owner's consent, otherwise known as twocking, taking without consent, and after the vehicle was taken, but before it was recovered, an aggravating factor has occurred. The aggravating factors are set out at Section 12A(2) of the Theft Act 1968. There are 4 aggravating factors. These are 1, that the vehicle was driven dangerously, 2, that a person was injured, 3, that the vehicle was damaged, or 4, that there was damage to property. Aggravated vehicle taking is an either-way offence. This means that it can be heard either at the Magistrates' Court or at the Crown Court. At the Magistrates' Court, a single offence of aggravated vehicle taking can be dealt with a maximum sentence for a single offence of 6 months custody or a level 5 fine, and, in the absence of special reasons, a disqualification period of 12 months. At the Crown Court, the maximum sentence for aggravated vehicle taking is 2 years custody, unless, as a result of the injury, there has been a death, in which case the maximum sentence is 14 years custody. I said that the Theft Act 1968, Section 12A was amended, and it was amended by the Aggravated Vehicle Taking Act 1992. That legislation was passed as a result of a spike in joyriding in the early 90s. That legislation provides that where there is a low value of damage caused, the matter is not either way, the matter is summary only. So where there has been aggravated vehicle taking but that the damage is low, the matter cannot go to the Crown Court, the matter can only be heard in the Magistrates' Court. And in that instance, the maximum sentence that a Magistrates' Court can impose for a single offence of aggravated vehicle taking is 6 months custody and or a level 5 fine. And in addition, in the absence of special reasons, the Magistrates' Court must also disqualify for 12 months. The Sentencing Guidelines Council have set out guidance on sentencing for individuals convicted of aggravated vehicle taking. For an individual with no previous record convicted following a trial, the starting point for a low-level offence with few aggravating factors and many mitigating factors. So, for example, where the individual has used their employer's vehicle beyond the authority passed by their employer and therefore has taken the vehicle without their employer's consent, the starting point is a medium level sentence. But of course, if they, for example, if they were to plead guilty at the earliest opportunity, then the range can be from a low-level community order. So in summary, the legislation for aggravated vehicle taking is Section 12A of the Theft Act 1968. That provides that where a vehicle has been taken unlawfully, taken without consent, where there is aggravating features between when the vehicle was taken and when the vehicle was recovered, that constitutes the offence of aggravated vehicle taking. Those aggravating features, there are 4 of them: the vehicle being driven dangerously, injury to a person, damage to property, or damage to the vehicle. The offence is either way. It can be heard at the Magistrates or at the Crown Court, At the Magistrates' Court for a single offence, the maximum sentence is 6 months custody and or a level 5 fine, and in the absence of special reasons, a disqualification for 12 months.